All right. Welcome back, Chalk and Gavel listeners. We've got a special episode for you today. We're bringing you another sidebar, right, Chris?
Our second ever sidebar.
Yeah, we are following up. We said we were going to do this in our first sidebar. We had a special guest in our first sidebar, Mark Walsh, reporting on the Supreme Court for over 25 years. He joined us on our first sidebar episode to talk about what was happening in the Supreme Court in the education-related cases. So we talked about that back in December. And now we've got Mark back with us today. It is the summer. A lot of decisions have come down from the Supreme Court back in May and June. And Mark is back with us today to talk about everything that happened. Welcome back, Mark.
Thanks, Jamie. And hello, Chris. Good to be back with you guys.
We are thrilled to have you. Thank you.
Yeah.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, so we're gonna dive into a handful of cases today that the Supreme Court ruled on this term that have something to do with education, either directly or sort of indirectly. Before we do that, let's have a real quick Title IX conversation.
Yeah.
Is that possible to have a quick one?
I don't know if it's possible to be quick, but the new Title IX regs supposedly went into effect August 1, though I think, Mark, it's a little bit more complicated than that, right?
Yeah, so this has sort of been consuming me here as we record this in early August. On August 1st, the Biden administration's broad new Title IX regulation took effect, but only in about half the country. And I'll explain that. I think your audience probably knows that Title IX prohibits discrimination based on sex in federally funded education programs. That means schools and colleges, certain other programs too, but primarily today we're thinking about schools and colleges. The regulation for the first time in a regulation protects students on the basis of sexual orientation and gender identity. It redefines sex discrimination to include those characteristics. The regulation also does a lot of other things, adding protections for pregnant students, setting out new grievance and due process procedures for sexual harassment and sexual assault, and it bolsters protections for retaliation. But it's the gender identity definition in particular and certain provisions that relate to gender identity that have been the main target of about 10 lawsuits brought by the states, 26 states, as well as some school districts and some private groups. Now, these lawsuits, there's groups of states. They're not all necessarily in the same circuit. Don't know that we need to get into why that is. So in all but one of those lawsuits, a federal district judge before August 1st issued a preliminary injunction to block the entire regulation from going into effect while other court proceedings played out. There was one federal district judge who refused to do that, who did not block the law, but she was quickly overruled by a federal appeals court just before August 1st, and that, at least on an administrative basis. And so in those 26 states, the rule is blocked entirely.
Wow.
Now, I would add, besides those states, one of those injunctions has an unusual provision that applies the injunction to any school or college that is attended by a member or the child of a member of three groups who were plaintiffs in this case. It's the Kansas case. And those groups are Moms for Liberty, Young America's Foundation, and Female Athletes United.
Okay.
I think Female Athletes United is maybe a little more focused on the college level. Young America's Foundation, I don't know that much about. But Moms for Liberty is a group that's gotten a lot of attention. So the rule is also blocked at those schools. And those groups are being allowed to build their membership so they can add more schools.
Wow.
So, and I don't know if we necessarily want to get into this, but those groups had said, well, these lists of schools are hard. Can we just do it by county? So could we block the regulation in any county where one of our members goes to school?
Oh, really?
That would almost turn it into a nationwide injunction.
Wow.
But the judge said no to that.
Oh, okay.
Now, the Biden administration took two of those cases, just the two that happened to be the farthest along a couple weeks ago, where in those federal appeals courts had refused to stay the injunctions. Took two of those to the U.S. Supreme Court on what's called the emergency docket.
Okay.
It's also known as the shadow docket, but the emergency docket is where things come up really before they're being presented to the court. On the regular docket, they've been played out in the lower courts. Here, the administration's saying we would like you to do something on an emergency basis.
Now, Mark, when they do that, are they bypassing the certiorari process and they're just saying, please take a look at this real quick?
Yeah, it's not necessarily that they're bypassing the cert process. It's that they're asking for some relief that's apart from a total merits review of the case.
Do they have to present this is a time sensitive kind of issue for us, so please look at it?
Usually, It is a time sensitive thing. Now, the U.S. Solicitor General has not been seeking a total reversal or total stay of these preliminary injunctions. She's only seeking a partial stay. The Solicitor General is Elizabeth Prelogar. And she said she is okay for now with the injunctions staying in place with respect to two provisions in the regulation that deal with gender identity. But because the administration will argue about those in the normal course of the case. But she did ask the court to restore most of the regulation and allow it to go into effect in the whole country. And she's also asked the court to restore the new definition of sex discrimination, which includes gender identity, and it's referenced throughout the regulation. And that part is a little bit trickier part to understand because the states are saying, we think the whole regulation should be blocked because, for one reason, this definition kind of pervades the whole rule.
Right.
But she would like to have the definition restored. But as a fallback, she said, well, you could sort of set aside, leave the injunction in with respect to gender identity in the definition.
Okay.
And we could go from there.
Okay. Wow. So this is what we're waiting on, right?
So as we speak, yes.
Okay, so just a little update for you listeners out there. We recorded this episode back at the beginning of August, and we were thinking, as Mark has mentioned, that we were hoping that the Supreme Court was going to make some sort of ruling on this prior to the Title IX regs going into effect on August 1st, and they didn't. We recorded the episode, and after we recorded it, the Supreme Court did issue a ruling on August 16th, and basically they decided to leave the new Title IX regulations fully blocked in those 26 states, as well as at those individual schools that had members of those three groups that Mark mentioned: Moms for Liberty, Young America's Foundation, and Female Athletes United. And there are schools in all of those other 24 states that are not covered by the statewide injunction. So essentially, the Title IX regs are on hold completely in 26 states, and in the remaining 24 in a bunch of other schools. So the scope of these new Title IX regulations is blocked significantly right now. If you want more on this ruling, definitely check out Mark's article in EdWeek from August 16th. He explains exactly where things stand now. Okay, so let's get back to Mark's interview. We do have a number of cases that the court did actually make rulings on from this season, this session.
Term.
Is that what it is? This season. episode.
It's a term, but it is often like either a school year, as we talked about,
Right.
or a season of a TV show.
Exactly. And it does often feel like this is some sort of sick reality show that we're all watching, right?
Yeah, the season finales have gotten a little bit. I think the Supreme Court jumped the shark in about season 2022.
Implausible and hard to believe, and can't believe these writers came up with this.
Yeah, that's right. Yeah, so let's. We talked about a handful of these cases when we talked with Mark back in December about the things that the court was wrestling with. So let's go ahead and bring some closure to some of these things here. So the first case we'll talk about is O'Connor Ratcliffe versus Garnier.
Like the hair care brand?
I don't think so.
They're probably
Not
a
sure
different Garnier, right?
how it's pronounced or if they have any relation. So I don't remember exactly, how much we went into this in the fall, but in this case, the justices heard the appeal of two local school board members in California who had blocked two parents from their personal Facebook and Twitter accounts. The parents were married, husband and wife, for allegedly spamming them with repetitious comments.
Oh, I remember this. Yeah.
Which were very critical, right?
Some of them were just irrelevant, or they were just spam.
Right.
One of the parents said that he and his wife were frustrated by the time limits on public comments at school board meetings, and they had tried to reach these school board members, and they were unresponsive to their emails. And these parents, they had some legitimate concerns about financial mismanagement in the district and some other issues. But the evidence in the case showed that on one occasion, this Christopher Garnier, one of the parents, posted 226 identical replies to one of the board members' Twitter accounts. The same reply to every tweet she had posted. And two lower courts ruled that even though the board members' social media pages were not official government outlets, they focused on school board business. So, and this has come up in the discussion of this case. These were not the official accounts, but they were the personal accounts that the board members kind of set up as their quasi-official, and they even at times use language like, this is the official Facebook page for this school board member.
Okay. Right, because they set these accounts up. These school board members set these accounts up when they were running for school board. And so they had like personal accounts, but these were like their candidate accounts that they kept using, and they kept posting about school board business and all that stuff.
Right.
Yeah.
And they did focus on school board business. And so thus the legal question for the blocking of some was whether the blocking of some constituents from these pages amounted to government action. State action.
Wow.
Right. Yeah. Because without state action, then it doesn't implicate the First Amendment if you're blocking people left and right.
Yeah.
Yeah. Because I remember this coming up during the Trump presidency when he was on Twitter, and he was, blocking people on Twitter, and people were saying like, hey, you can't do that. Like, this is an important public forum. Like, that violates my First Amendment rights.
And that went to the Supreme Court. And by the time they had to do something about it, he was no longer president. So they just said, we're not going to deal with that.
Right. And by the time this case was argued, President Trump and his Twitter habits were discussed during the oral argument in these cases. And when I say these cases, there was another case that the court heard separate oral arguments about involving a city manager, similar kind of thing. It was the city manager's personal account where he discussed a lot of business and then blocked some constituents. So that, as it turns out, is the operative decision as the court reaches a decision in this case. Now, I'll tell you what happens to the school board member's case as we get to it. But if you're looking for that decision, it's called Linke versus Freed. And in that case, Justice Amy Coney Barrett wrote for a unanimous court that officials may be sued in some circumstances, but she set a test that will kind of shield many posts and actions by government officials from First Amendment scrutiny. She said officials would be engaged in state action only if they have the authority to speak on the government's behalf and are exercising that authority in specific posts on their personal social media pages.
Okay, so essentially you have to be a government figure talking about the thing you're a government figure for, and the post itself has to be about your work with the government.
Right.
Okay.
And this is from her opinion. Justice Barrett said, such officials may look like they're always on the clock, making it tempting to characterize every encounter as part of the job. But while public officials can act on behalf of the state, they are also private citizens with their own constitutional rights.
Wow.
Barrett said many of the nation's 20 million state and local government officials, including governors, mayors, and teachers, use social media for personal or official communication or both. And in her words, and the line between the two is often blurred. She cited an example that had come up at oral argument, and they were throwing out some non-social media examples to try and, help themselves decide the case and think about the case. Justice Barrett is saying a school board member announces at a board meeting that pandemic-era restrictions were being lifted. The next day at a backyard barbecue with friends who have children in the school system, he shares that those restrictions have been lifted. He says that again. The first example at the board meeting would be state action, but the second at the barbecue is not, because he's just speaking as a friend and neighbor. So they were using those non-social media examples, as I said, to help frame the issue. They talked about, running into people at the grocery store. Is that something the school board president says they're going to be considered official action? So then, move that to the internet. And Justice Barrett said that the appearance of the actual page will not determine whether it is state action, because some officials' pages are labeled official even when they're just the personal Facebook page of that official. Now, Justice Barrett really only kind of briefly delved into the issues around an official blocking a critic from a social media page, the actual blocking. And she said, the bluntness of Facebook's blocking tool really highlights the potential legal hazards of that kind of mixed use social media account. And she said if page-wide blocking is the only option, a public official might be unable to prevent someone from commenting on his personal posts without risking liability for also preventing comments on his official posts. And so there, a public official fails to keep personal posts in a clearly designated personal account, kind of exposes himself to greater potential liability.
Interesting. So if you block somebody from your post or from your personal account, but at some point you have a post that meets this test of you're speaking on the state's behalf and you're exercising your authority to speak on the post, then that block itself might become problematic because of that one post.
I think that's what she's saying.
Interesting.
And that's, it's kind of a case-by-case test, she seemed to emphasize. And some kind of labeled this as a pretty, modest decision, a decision of modest scope. That may be true, but there isn't that much guidance out there for this kind of thing. So it could be interesting. And just to come back to then the school board member's case.
Yeah, what happened?
So the court dealt with that in what's called a per curiam, which is an unsigned decision. The fact that they were kind of dealing with these issues in one case was, it pretty much applies to their case too. But since both of these cases, the court was sending them back to the lower courts to deal, to look freshly at the facts of those cases. So it did that in the school board member's case with a per curiam. Justice Barrett happened to announce that per curiam from the bench, and she probably is the one who wrote it, but it is listed as by the court.
Wow.
Yeah, so the bottom line of those social media cases is if you're a public official, be careful about commingling your private and public accounts. And if you put anything public about your public business on that account, be really careful about how you treat people's comments and blocking people from that, because you may have inadvertently created some sort of state action or public forum.
Yeah.
And I think it's not just like an elected official board member, but, people with power. So the superintendent and maybe other officials in a school district.
Oh, sure.
Yeah.
Yeah. And that's the thing, with these positions, if you're going to put this stuff out there, you have to get kind of comfortable with criticism. And I think that's where a lot of this stems from, is people don't like the criticism. But just because it implicates the First Amendment as public action doesn't necessarily mean that it's a First Amendment violation. So Mark, you mentioned the person who posted the same comment on 260 posts, one, that's repetitive, and two, that also means that comment is not responsive to every single post. And so there's going to be neutral, viewpoint neutral restrictions that you can put on stuff like that for relevance and duplicity and all that stuff that may make it not a First Amendment violation.
Right.
But I know that's not the only case that we've got. What do you got next for us, Mark?
Okay, so this next one I think we also discussed in the fall is Muldrew versus City of St. Louis. And this case really helps define when a city or a school district's decision to transfer an employee, such as a police officer or a teacher, is covered by Title VII. Talking about Title VII of the Civil Rights Act of 1964, the main federal job discrimination law protects based on race and sex and several other characteristics. This case involved a police department and a female sergeant named Jatanya Muldrew. And just to give some of the background, because I think it's pretty interesting to this case, she had worked 9 years in the intelligence division of the St. Louis Police Department, had once led the gun crimes unit, and she had some special FBI credentials to work with, the federal agency.
Very cool.
But at some point, a new supervisor came along, a man who said, essentially, this is, and he used these words, this is very dangerous work for you.
With the implication being it's not too dangerous for a male employee?
That is the implication, yes.
Okay.
It's not been proven yet, but he transferred her to a regular police precinct. He also transferred other women out of the intelligence division. Back in the regular precinct, she had to wear a uniform again and do routine patrol, or she was supervising routine patrol, but she brought a sex discrimination claim under Title VII.
Okay.
So that moved along, and the U.S. Court of Appeals for the Eighth Circuit said, yeah, there may be some evidence there, but there's no adverse employment action in that kind of transfer.
Oh, because it was essentially a lateral.
Yeah, so we are talking about lateral transfers.
Okay.
So the briefs all along in this case have talked about all kinds of school employee cases. And in one of them, for example, in a 2016 decision, the federal appeals court ruled that a black school security officer who was transferred from a high school to a middle school did not suffer an adverse job action, despite his claims that the middle school position was just less prestigious generally, and it didn't offer any possibility of overtime pay as the high school post had.
Okay.
And there's some others like that. But on the other side, in a 2000 ruling, a different federal appeals court held that a female high school principal who was transferred to a central office position could proceed with her suit because lateral transfers resulting in a, quote, loss of prestige and responsibility were covered by Title VII. There have been a number of these cases that have involved transfers of a principal to the central office. And sometimes that is a promotion, sometimes, not, as you can sort of imagine.
Sometimes that is a strategic choice.
Yes. So that case was allowed to proceed. School groups like National School Boards Association, secondary school principals, elementary school principals, they had filed a brief in this case telling the court that, we need to be nimble and make transfer decisions in education about teachers and other personnel. And there are lots of questions like, what if it's just a temporary transfer? Someone's going to be out for a few weeks and we need to transfer that teacher into a classroom. Does that implicate Title VII? So I'm not sure the decision answers all those questions, but for the court, Justice Elena Kagan wrote the opinion, and she said, to make out a Title VII discrimination claim, a transferee must show some harm respecting an identifiable term or condition of employment. That means regarding, a term or condition of employment. The employee does not have to show that the harm was significant or serious or substantial or any similar adjective suggesting that the disadvantage to the employee must exceed some higher bar.
Okay, because that was what a lot of other courts had ostensibly been doing, is they'd been kind of like raising the bar to pass go on a Title VII.
Right. Some had, and there was split.
Okay.
There was definitely a circuit split on this. Now, 5 members of the court signed the majority opinion along with Kagan, and the judgment overall was unanimous, but there were 3 opinions that just concurred in the judgment, concurred in the outcome. And I wasn't really going to go into all of those, but Justice Clarence Thomas would have used a slightly higher bar. He wanted more than trifling. And Justice Brett Kavanaugh would lower the bar and said just the transfer itself is the adverse job action.
Yeah, I was surprised by that, to see Justice Kavanaugh basically say, hey, any discrimination, like any transfer at all, could trigger Title VII because the harm is the discrimination itself, not necessarily the transfer, because any transfer is going to deal with kind of the roles and duties and like prestige, or I forget the exact word he used, but like the conditions of employment.
Wow.
Right. And employers definitely don't want that, but that's not the standard under the opinion.
You still have to prove discrimination. So like, even if you establish that the transfer was harmful, you still have to prove the decision was based on impermissible discrimination.
Right. And lastly, as far as the justices who wrote opinions concurring in the judgment, Justice Sam Alito wrote something that he just felt Justice Kagan's opinion was, quote, unhelpful. He didn't think she was providing enough guidance. So
thank you for those comments, Justice Alito. Yeah, because didn't that opinion go on, like, Justice Alito's concurrence goes on to say, I have no idea what this means.
Right.
Thanks, buddy.
Yeah, right? Like,
speaking of unhelpful.
Wow. All right. But yeah, so that one's really interesting. Like, basically when does school transfer is triggered? And like the kind of the bottom line is this some harm standard, which kind of says, like, if the new position alters like the terms or conditions, or, it doesn't have the same perks or the same benefits or whatever it might be, like, that's going to potentially get you through the door for alleging a Title VII violation, which means that, like, you're challenging whether or not that promotion or that transfer rather was based on impermissible discrimination, race, sex, religion, whatever it might be.
Exactly. So, and there's just many, of these decisions every day, because these, school districts just by their nature are pretty large employers, large enterprises, and they do have to make these decisions
right,
quite often. So,
and that doesn't say they can't make those transfer decisions. It's just got to be careful about, like, obviously not basing them on race, or, as it sounds like that decision for that police officer was based on potentially some underlying sexism.
Right.
Perhaps.
So far, a couple of cases, nothing that feels earth-shattering in terms of setting new precedents or whatever. It's just, there's a lot of like, just remember, be careful.
Yeah, we're tinkering at the edges with these. Obviously, that's not all the Supreme Court did.
Yeah. And that's pretty much what the court did. This was not a huge term on the merits docket for education law, the way some recent terms have been.
Right.
But I get paid to look for education angles in all kinds of cases.
Yeah, no, totally.
Which leads us
including
to
our
Snyder.
The next one. Now, the next one was a big one, right?
This is a big one, because...
So here's a case I didn't end up writing about, but I'm now kind of thinking maybe I should have. I think it's worth discussing. I'm sure...
So wait, does that make it a chalk and gavel exclusive?
Oh.
Do we have a Mark Walsh exclusive?
It is for now, yes. Let me say, I'm sure everyone listening today to your podcast who works in public education is a fine, upstanding public servant who wouldn't think about taking a bribe or a gratuity, an illegal gratuity. But this whole case revolved pretty much around what might constitute a gratuity under a federal bribery statute that covers state and local officials. And some of the justices were quite concerned about possible prosecution for things that we kind of think of as the norm in education, like a gift for the teacher. So I'll get into that. The case involved the prosecution of a former mayor of Portage, Indiana, named James Snyder. And he received a $13,000 consulting fee from a contractor that he had picked to supply the city with new garbage trucks.
I could hear those air quotes, Mark.
Yes. I mean, so this was after the fact.
It's very similar to those Christmas gifts for teachers, right? $13,000, right?
So
I gave you $1 million worth of A's and you gave me $13,000.
So he was charged and convicted under this federal bribery statute and sentenced to 21 months in prison. There's some other charges. I won't get into all the complications of his case. He's not totally in the clear here, but the Seventh Circuit upheld his conviction, holding that this federal statute applies to gratuities as well as bribes. So, bribes involve a quid pro quo.
Essentially an agreement, I will do this if you give me this, right?
Right.
Yeah.
So in appealing his case to the Supreme Court, Snyder's lawyers, they said that this provision, using it to prosecute over gratuities, has really become the beast of federal prosecutors because it doesn't require them to prove that quid pro quo. Now, I'm going to try and explain that this statute, which is called Section 666.
Appropriate, yeah.
And I feel like there should be some scary music.
Is that why they called it the beast of federal prosecutors?
Well, quite possibly.
Yeah, that's low-hanging fruit. I like it.
So it's important to note that this statute applies only to transactions worth $5,000 or more. But that's not the value of the gift or gratuity that we're talking about, but the value of the government employee's service.
Okay.
So several members of the court were quite concerned even about, parents' simple gifts to teachers.
Yeah.
because, the concern is that the value of the government service, if it was for the whole year, then the salary would quickly add up to more than $5,000. So they wondered, would a Starbucks gift card be okay? What about a gift card to a relatively inexpensive restaurant? What about one to a fancy restaurant or one in the middle? So here's Lisa Blatt, the lawyer for the Indiana mayor, at oral argument.
I mean, the restaurant example alone, I don't know where I'm pretty sure Chipotle would be okay, and at Little Washington wouldn't, but ask them about the Cheesecake Factory.
Well, I'm not going to ask them about the Cheesecake Factory. Somebody else may.
Okay.
Cheesecake Factory seems, I don't know. Well, so this is federal law, right? Like this isn't state or local policies, because most states have policies for what government employees can accept, right?
Right.
But yeah, so Cheesecake Factory in Ohio, I think it was $25, which I think that probably is over the threshold.
Yeah. So, and there was quite a bit of discussion about some of this is covered by state laws, but this is, we're talking about federal prosecutions. We're talking about concern by the justices, particularly on the conservative side, of overzealous federal prosecutions.
Sure.
Now, coming out of that clip, just to understand, in at Little Washington that she referenced, that is a fancy restaurant outside of Washington. I've never been there, but the Cheesecake Factory is one of my favorites, and that came up several times in this argument. In fact, here's Justice Neil Gorsuch addressing the federal government lawyer defending this prosecution.
How does somebody who accepts the Cheesecake Factory know a trip to the Cheesecake Factory for nice treatment at the hospital, for treating my child well in school, for an arrest made? How does that person know whether that falls on what you call the wrongfulness side of the equation or not?
When you say the hospital, when he says the hospital, this law also applies to nonprofit organizations that receive federal funds. So that could be a lot of hospitals.
Gotcha. Okay, so his concern is I don't know when I see it, I guess, because we're basically rewarding people for past acts, and how do we know where that becomes corrupt versus permissible?
Right. So what their concern is how much of a gratuity is too much, because there were some examples of prosecutions that involved seemingly, gratuities that were not at the level of $13,000. So here's just one more clip, and this is Gorsuch again asking the government's lawyer about that $5,000 threshold for the services provided, which, the justices made clear would not be hard to meet once you start taking into account the public employee's salary when part of their work was going for certain, whether it's special treatment for a constituent or just work that the constituent, felt the need to thank them for.
So anytime an employee at a hospital does more than $5,000 worth of work on behalf of a patient, or a teacher spends more than $5,000 worth of time with a student, then that threshold would be satisfied in the government's view.
Where the specific transaction and business is worth more than $5,000, yes.
Okay, thank you.
Ooh, I don't know if I would have answered it that way.
This is a weird one, man. It's all about value, right? How much value you assign to something. But they're coming up with these dollar amounts.
Well, I think the dollar amounts come from the statute, but
the dollar amount of the government services provided is set in the statute. But where the concern is that the gratuity is not. So where is that line? That's what they were trying to get at.
But that's what I mean. If it's a gratuity, how do you define that? Because what one person values, is going to be very different than what somebody else does. And you know what? To be honest with you, if we're talking education, we're talking teachers. I mean, you could have a teacher that goes above and beyond for a kid, right? And changes that kid's life. Right?
For sure.
And so what if one parent can afford something more than a $10 gift certificate?
Maybe an all expenses paid flight to a fishing lodge in Alaska.
But
hypothetically speaking, Justice Alito.
But yeah, it's not out of the realm of possibility, right? That a parent is what? This teacher's getting 100, 1,000, whatever.
Sure. But the statute itself, I'm going to do what every lawyer loves to do, and I'm going to go back to the text of the statute. The text of the statute says that it's a crime to accept anything of value from any person intending to be influenced or rewarded. So there's an intent requirement here where the person doing the government action has to take something of value and intend by the taking of that to be influenced or rewarded for the thing that they did. And so like, if I'm going above and beyond as a teacher, like maybe I'm doing that because I love my kids, not because I expect this rich parent to end up ponying up for a trip.
Yeah.
Right. Because it's the intent requirement. I think that's like,
so that's the key.
I have lots of issues with this decision. And one of my biggest issues with this decision is like, they're ignoring the like plain language of the statute where it says, or rewarded, where like a reward comes after the fact, right? So like this entire decision rests on this premise that like, it can't be a bribe if you accept something after you did the act, unless there's a quid pro quo, in which case then yes, we go to bribery.
And you didn't do the act with the intention of getting the reward.
Right.
But
like,
and that is part of it. So let's get to that decision. So now the opinion comes out in June, and the Supreme Court rules 6-3 that this provision of federal law, it prescribes bribes to state and local officials, but does not make it a crime for those officials to accept gratuities for their past acts. Justice Kavanaugh wrote for the majority, and he said gratuities, those are typically payments made to an official after an official act as a token of appreciation. He says, quote, some gratuities can be problematic, others are commonplace and might be innocuous. A family gives a holiday tip to the mail carrier. Parents send an end-of-year gift basket to their child's public school teacher. A college dean gives a college sweatshirt to a city council member who comes to speak at an event. I like this one. A state legislature's neighbor drops off a bottle of wine to congratulate her for her work on a new law. Now, I do wonder whether the teacher would just rather get the bottle of wine than that
right.
gift basket with the apple or another world's greatest teacher mug. But Justice Kavanaugh, also threw out examples like, what about a $100 Dunkin' Donuts gift card to the teacher or public worker, or students taking their professor out to Chipotle? Does that happen often?
I'm open to it.
Yeah.
He said the government offers no clear federal rules for state and local officials. So how are state legislators, city council members, school board officials, and he goes through a whole list of public officials, but including high school basketball coaches, which he's a former volunteer coach on his daughter's private school basketball team. He wants to keep them in mind. How are they to know what is acceptable and what is criminalized by the federal government? They cannot. The government's so-called guidance would leave state and local officials entirely at sea to guess about what gifts they are allowed to accept under federal law, with a threat of up to 10 years in federal prison if they happen to guess wrong.
Oh, boy.
Sure, I guess I see his perspective, but like, to me, all of that's handled by the statute where it has this intent requirement for the government official, where like the government official has to act with the intent to be influenced by the gift or the gratuity. So like, you have to like, as the public official, assume you're going to get the gratuity and take some action because of the gratuity to violate this statute as I'm reading it. And so like, I guess like, I get where he's coming from, but like the optics of this current Supreme Court saying, hey, after the fact gratuities don't violate federal law, like, it is not a good look.
And there's, dissent, but just, the perspective is that, the court has trimmed back a lot of white collar and federal, official corruption laws in recent years. And one of their just general concerns is that they're not going to accept from the federal government the idea that prosecutors are going to be just using their discretion in these cases. They want it to be a little more clear than that.
Okay.
So writing in dissent, just very briefly, Justice Ketanji Brown Jackson said, prosecutions of gratuities that the government has brought under this section, successfully or unsuccessfully, do not remotely resemble the holiday tips and gift baskets and sweatshirts around which the majority crafts its decision. Even as the government has consistently maintained that Section 666 covers gratuities, its actual prior prosecutions under the provision were not the dragnet for public school teachers, soccer coaches, or trash collectors that the majority conjures.
Yeah. And then again, this does nothing to affect kind of state and local rules and laws and policies that dictate what public employees can accept when it comes to kind of like, I guess, related to their public work. So like, I guess more so just the optics of this than anything. The joke that I read is that it basically makes federal bribery. It's only bribery if it comes from the Berberay region of France.
Well, I don't know if you should rely on that. So that's what I have on that one.
Okay.
Yeah. And then the last case is one that I think we've talked about on the show before, Loper Bright Enterprises versus Raimondo. But I know that this is a really big case, Mark, that you've written about and about its potential implications for education too, right?
Right. As I wrote initially in Education Week, what does a case about federal observers on commercial fishing vessels possibly mean for education policy? So in this case and a companion case, the court took up a challenge to a federal rule that required the fishing industry to pay for these observers who they actually join the vessels and they're there to count fish and prevent overfishing. These happen to be herring fishermen in the Atlantic. But the court made it clear when it accepted these cases, it was really interested in using it to reconsider the 1984 decision that generally requires courts to give deference to federal agencies' reasonable interpretations of statutes when those laws are silent or ambiguous on a particular matter.
Mm-hmm.
And that precedent is known as Chevron versus Natural Resources Defense Council. It's the source of the Chevron test, which has been criticized for years by conservatives as helping vest greater power in federal departments and agencies, including the U.S. Department of Education. Now, there were lots of briefs from business groups, business interests in this case, because they're the ones who really would like to see Chevron go. Only one really raised an education issue, and I wrote a little bit about that, but it was filed by a particular group, but it was written by Alliance Defending Freedom, and that's a private group that has really been on the forefront of transgender issues, of seeking to, not enlarge transgender rights, and have been fighting with the administration and is behind some of these lawsuits over the Title IX rule. And just in the briefing, they raised the question, because at the time, the Title IX rule was not final, as to whether, if you keep Chevron around, then that's going to give the Education Department something to hang the new rule on.
Sure.
Mm-hmm.
Now, as it turned out, the Biden administration did not really invoke Chevron in these cases. We mentioned that the lawsuits by the 26 states and school districts and so forth. I found at least one of those before the Loper Bright ruling, the administration told the court that it was not relying on Chevron at all for Chevron deference for this particular regulation.
Interesting. Probably reading the writing on the wall.
Right.
I think that's right. And there were these two rulings that were on these preliminary injunction decisions that were ruled on before Loper Bright, and those judges did go through the motions of Chevron deference test or an analysis. But even then, they kind of made quick work of it and said, well, we don't think Title IX is an ambiguous statute on this point. So that's end of story.
Oh, sure. Which is funny because the Supreme Court recently said that Title VII, like the meaning of sex under Title VII, could incorporate transgender and gender identity discrimination.
And that goes to the heart. That is really the heart of what is going to be ultimately decided in these fights over the Title IX rule, whether that Bostock decision, and the conservatives will say, well, Justice Gorsuch in the Bostock said this is not about other laws or other situations.
Right.
But Justice Alito had written a long dissent in Bostock that said, this is what I'm afraid of.
This has potential implications. Right. Yeah.
Right.
That is going to be the big question. But so we're not quite there yet in the Supreme Court. But if the court takes it up. I did, do some research, found I was trying to explain this for our audience, a bunch of cases where Chevron was the critical factor in courts, going back, 10 years or so, maybe even longer, courts upholding certain education department regulations, including one about peer racial harassment under Title VI of the Civil Rights Act, some regulations under the Individuals with Disabilities Education Act. And I found in other cases, judges did the Chevron analysis and ruled against the department a few times. Now, I've also heard from some legal experts about education department rules that they would like to revisit now that this Loper Bright decision has come out, which, by the way, the decision did explicitly overrule Chevron. And now there's some questions about how they might go about that. This is starting to strain the limits of my expertise. But there are statutes of limitations under the Administrative Procedure Act for challenging regulations. I think it's 6 years. But there was also a decision from this court this term called Corner Post that made it easier for certain parties to challenge older regulations. And Justice Jackson wrote a sharp dissent in that case, and she read part of it from the bench, warning that the combination of these two cases will really have staggering effects on federal administrative law.
So we could see challenges to regulations that have been in place for decades?
Possibly.
Is that kind of the implication here? Oh,
possibly.
Gosh.
Now, this is, again, getting way outside my expertise. Corner Post, it happened to be Corner Post was a new convenience store that popped up, I think, in Idaho. Did not exist when there was some Federal Reserve rule that went into place, and it came along 6 years after that about, use credit card interchange fees and that, something like that. And the essence of this Corner Post is that that's a new injury because this time clock on statute of limitations started again when this new business opened. Now, I don't know how that would apply to public entities like a school district or a state. We haven't had too many new states recently or...
Right. Well, isn't there something about like coming to the harm? Like if that was already in place and you came to the place to open a business, like you open the business knowing about that thing.
That might have been addressed in Corner Post. I don't remember offhand.
Yeah. But so like, I think Loper Bright Enterprises is, it's really important, right? And we're kind of trying to unpack how it's going to play out in education. But it kind of just says that these agencies, when their actions get challenged in court, it's the independent judgment of the court that's going to matter to determine whether or not the agency's actions are going to be upheld, depending on kind of like how the statute delegates authority and all these other things. But like, Jamie and you and I have talked about this, like it shifts power away from these agencies to courts or to the legislature, depending on how you look at it. Right. And so like how it plays out in education, I think is going to be really interesting, especially if this opens up very established regulations. Because, I'm thinking about the IDEA regulations. We've had the same IDEA regulations for a while now. Yeah. So like if those are subject to challenge now and all these other things, like it's going to be really, I think, Jamie, I joked
messy
the last time. Yeah, it's going to be messy. It's going to be like everything is now unsettled, it feels like.
Well, I think that's right. And I don't, know for sure how it would play out with these older regulations. But going forward, the whole goal of this movement was to restrict the power of federal agencies, federal departments, and
mission accomplished.
All this is that Congress could do a better job of being specific, but there are many things, and I don't think necessarily the Education Department is probably not the best example where the expertise of the agency is really shown, Justice Kagan.
It's not really technical, right?
Right. It's maybe a little less technical than, say, the EPA or the Food and Drug Administration, where Justice Kagan in her dissent in Loper Bright had some examples, and she was going through them in court about the Western gray squirrel and all these others that she brought up. So
yeah, because like that idea about like the legislature needs to be much more explicit about what kind of authority it's delegating to the agencies. And so I think like the whole movement here is around like, we want to make sure that these agencies are accountable and that they're not just exercising unchecked power because they're politically insulated, right? Like we don't vote for the Secretary of Education. We don't vote for the head of the EPA. So we want to make sure that the people we do vote for are the people who have the ultimate say. And I think I understand that concern. The only problem is like we've been passing statutes for 40 years with very, let's call them vague delegations of authority. So like Chief Justice Roberts, who wrote the opinion in Loper Bright, he wrote that like the court has to exercise its independent judgment. And it does that by essentially like looking for delegations of authority to the agency from the legislature, deciding on the boundaries of that authority, and then ensuring the agency has engaged in what he called reasoned decision-making within those boundaries. And so it's all going to come down to the delegations of authority. But like, if you look at some of these laws that we have regulations for, Title IX's delegation of authority is incredibly broad. It has like, it basically just says that every agency that is empowered to extend federal financial assistance to any educational program or activity, so basically the people that Title IX applies to, is authorized and directed to effectuate Title IX with respect to such programs or activities by issuing rules, regulations, or orders. That's the entire delegation of authority. So it basically just says, hey, go out and effectuate this non-discrimination provision. And that like, now we have to figure out like, how far does that go with this grant of authority?
Yeah.
And yeah, it opens up a whole big old can of worms, but which had, potentially already been let out of the can because the court makes a big deal about they hadn't relied on Chevron since 2016.
Yeah. The court itself had not, but lower courts had been applying it usually.
I guess it's just a wait and see game now to see, like who's going to test this.
Right. And how's it going to be tested and how's it going to play out? Right.
Exactly.
Because, there's a version of this where it's like, okay, well, courts have always told us what the law is. Like, that's what the job of courts is.
Yeah.
So this doesn't really change all that much, potentially, but obviously we'll have to see how this new standard from Loper Bright gets interpreted and understood by the courts related to that delegation of authority issue.
Yeah. Well, that's interesting.
Yeah. So now there's a couple cases, Mark, that we talked about in the winter that the court ended up not taking, right? So like, I think we talked about Coalition for TJ versus Fairfax County, which Jamie and I covered in episode 14, which was the whether or not this elite school's admission changes had an impermissible racial motivation. There was a couple others that I think we had mentioned, Metropolitan School District of Martinsville versus AC, which was whether or not Title IX or the Equal Protection Clause prohibits schools from maintaining separate facilities based on biological sex. I think there was also a couple others about discipline with students with disabilities, things like that. So those are all cases that the court decided not to touch at this time.
Right. I'm glad you remembered which ones because I didn't necessarily.
I went back and listened.
So, the court doesn't take everything. A lot of people were surprised about the Coalition for TJ case, and Justice Alito, joined by Justice Thomas, dissented from that denial.
He was pretty adamant in that dissent.
Right. My sense was that the court did not want to jump right back into these affirmative action type questions.
Right, after the Harvard case.
Right, and we don't know what's in the law clerk pool memos or what other, forms of the internal debate over these, whether this case, maybe had some deficiencies or just concerns for certain justices.
Oh, sure.
I will say, I don't know how much we're going to talk about next term. There is already a cert petition pending for the court possibly to act in its first orders list back from summer vacation that comes from Boston, and similar to Coalition for TJ. The Boston School Committee had overhauled the criteria for its competitive exam schools, and they were sued over that. I won't go into all of it.
Interesting.
But I think that has even less of a chance or has equal chance of getting granted as the Coalition for TJ case because the particular criteria at issue were only in place for one school year, and they've moved on from that. And I'm sure the people who are bringing it to the Supreme Court would disagree, but I just don't expect the court to take that one either.
Sure. And that raises similar concerns about like the use of race or racial considerations when deciding enrollment policies.
Yeah.
What was the name of that one?
So that is Boston Parent Coalition versus School Committee for Boston.
Okay. And it's a pending petition?
Yes.
Nice. Okay. Yeah, there's a couple other pending petitions too that we're keeping an eye on, right?
Yeah. So another one, you guys talked about Oklahoma Virtual Charter School Board and its approval of a religious charter school, a Catholic charter school.
Yep, we did, yeah.
I have not seen that petition show up at the court yet, but but the people said, they voted to file it, and I think it's coming. I did notice there's a similar case that's pending that was really flying under the radar. It's called Heil versus Michigan, Hile, and it challenges Michigan's so-called Blaine Amendment, which I don't know if you all know what a Blaine Amendment is, but it's kind of a state constitutional provision that bars aid to religion. And Michigan did not enact its such provision until like 1970. Most of these were in the 1800s. For the states that have them. And the question in that case is whether state constitutional amendment barring direct and indirect public financial support for parochial and other non-public schools violates the Equal Protection Clause. So I didn't, study it super closely, but this does stem from like the defeat of a voucher proposal in Michigan. Okay. But the state comes back and says, like, by the way, this doesn't just apply to aid to religious schools, it applies to any non-public schools.
Okay.
Right.
So it's neutral.
Yeah, I was going to say that explains why it's a 14th Amendment challenge. Because when I first saw this petition, I was like, what? Wait, why aren't they not bringing a First Amendment claim? But it's because it applies to both parochial and other non-public school options. Okay, that's interesting. Okay, so there's a chance that the Supreme Court might take up either of these cases that deal with the public funding of religious education in different ways.
Right. I got to study this Michigan one more. I think the Oklahoma one will be. I'm eagerly awaiting that one to see how that goes, and
totally
that won't be briefed for that first meeting back. But just so your audience understands, the court goes through these on a rolling basis. It's always adding, and it just reaches a point. It's so in its next term will start the first Monday in October. It's got some cases on its docket, but we'll be adding more, and then it reaches a point where it keeps adding cases, but they're for the next term, and
right.
So
right.
Okay.
we always have
so we'll have to bring you back in December to talk about what's been accepted.
Right.
Mark, the Supreme Court has already accepted a case that will have implications for education related to Tennessee's law about gender affirming care. Is that? Yes.
So Tennessee Senate Bill 1 is similar to laws in quite a few other states. I don't know the exact number, but it prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex. So these are the laws that are about medical treatment for transgender young people. Mm-hmm. Those are of interest to the education community for various reasons by themselves and of potential importance. But here, the case the court accepted, which was from the Solicitor General, took it to the Supreme Court. And the Solicitor General said the Sixth Circuit decision implicates multiple circuit conflicts about the application of the Equal Protection Clause to laws that target transgender individuals. And some of those cases have been like school restroom cases.
Right. Yeah, like Grimm and yeah.
Right. Grimm and Whitaker in the Seventh Circuit. Those laws and the conflicting court decisions about their validity are creating profound uncertainty for transgender adolescents and their families around the nation. That's the Solicitor General speaking there.
Oh, wow. So that could have huge implications because that would tell us which tier of constitutional scrutiny applies to transgender or gender identity discrimination.
Wow.
Interesting.
And in some of these school cases, they've been both Title IX and equal protection. And to, the Gavin Grimm case from, he was a student in Virginia, the Fourth Circuit ruled for that transgender student on both grounds.
Right.
But some have kind of dealt with one or the other. And so this could be, we have the Title IX track going. We have equal protection.
Sure.
So could be another big year.
Well, yeah, that's kind of the thing with this Supreme Court right now. Every year seems like a big year, right?
Oh, boy.
Because just to kind of zoom out a little bit, the Supreme Court, obviously, we talked about a lot of the stuff that they did that relates to education, but like Loper Bright Enterprises, like that was a huge deal for everybody because it basically goes to kind of how American government works at the federal level,
right?
And kind of the balance of power between these executive agencies and these other branches. But, this was a pretty serious term in regards to like how the government works with Loper Bright. And then there was also the presidential immunity case too, right? The presidents have absolute immunity for their...
What was that one about again?
It didn't get much press, which I'm surprised.
Yeah, you would have thought. Enormously big term, obviously.
Yeah. But, there was also a few other things where the court didn't go as far as they could have gone, right? They're kind of not rolling back, but Mark, to your point earlier, like they're kind of like, maybe we don't want to touch that right now because there were abortion cases before the court that they either dismissed for lack of standing, or they said, this case is now different, so it was improvidently granted. We're not going to look at it right now. There's also a gun rights case that the Supreme Court upheld a restriction on folks who had been adjudicated as a credible threat, having their kind of being temporarily disarmed, consistent with the Second Amendment. So that was like a domestic abuser situation. So there's a couple cases here where like the Supreme Court didn't go as far as maybe they could have gone or people were worried about them going.
The court does, retain the ability to surprise with some of these decisions. Yes. And of course, there are all the issues swirling around the court around ethics.
Right, which we alluded to earlier, right?
The court came out in November with its own ethics code. And then things were kind of quiet for the good part of the term until we get to spring and there were controversies over flags flying at a justice's home, Justice Alito, the upside down American flag, and another flag at his beach house, and more questions about trips and so forth, involving some of them. I do note that, just in the last couple of weeks, Justice Kagan was making her appearance at the Ninth Circuit Conference she was in Sacramento. She's the circuit justice for the Ninth Circuit. And she, someone pointed out she's been kind of the in-house scold because she was, talking to judges, but saying like, we put out this ethics code, but we, really could use an enforcement measure. And that's one of the chief criticisms against it.
Yeah.
And that's what President Biden would like to see in his proposals to reform the court that he just came around to.
And that's a huge deal that President Biden proposed these Supreme Court reforms.
Maybe.
Well, I guess like proposing them is one thing, getting them enacted is a totally different thing, right? Yeah. But like it's already we're seeing some public back and forth with the justices and, what this might mean. But like Biden's reforms, they seem to be at least in response to the presidential immunity decision and some of these other big decisions that kind of like reshape governmental authority. So, his three proposals were essentially reverse the presidential immunity decision, adopt an 18-year term limit for Supreme Court justices, which is consistent with a lot of other constitutional democracies, and then have a binding code of ethics, to Justice Kagan's point, that is enforceable by somebody other than the people that it regulates. But, I think going back to that idea of that back and forth, we're recording this in early August. Justice Gorsuch just came out and said that like people looking to reform the Supreme Court should, quote, be careful, because of the importance of an independent judiciary. So like, it's going to be interesting to see how this all plays out, because it is a give and take with this, these other two branches of government saying, hey, Supreme Court, we maybe think you've gone too far.
Yeah.
There's definitely some divergent opinions among the justices about some of these reform measures.
Right.
I went back just in preparation for this to look at the report that's mostly sat on a shelf for a couple of years at the White House, the President's Commission on the Supreme Court, whatever it was called officially, but did do a very thorough and good job of exploring some of these issues. And I was looking in particular at the 18-year limit, and there are lots of things considerations that I hadn't even thought about. One is whether you could do that with the constitutional amendment or not, and there's diverse opinion about that. But I do recommend people, if you're just at all interested in these things, go read that report. The commission was not allowed to make recommendations. They just were allowed to explore these things, but they did their job. And
interesting.
And it's worth taking a look at.
Totally. Yeah. The push and pull of like Supreme Court politics is really interesting, because this isn't the first time in American history where like there's been a loss of faith in the Supreme Court that, is more, I guess, more acute than usual. But like usually there's a political kind of backlash, and then there's a course correction. And, we've seen this a couple of times. So it's kind of a cycle. It just, may you live in interesting times. We get to watch the cycle play out in real time.
Right. Exactly.
It's interesting that, when FDR's court packing plan, as I recall...
You weren't around for that,
I wasn't around. Started covering the court a few years later. It was designed to, his New Deal programs had been struck down, some of them, and it was a little complicated. But if you were a certain age, or you would have to leave the court, it would have pushed some people off the court right away, as I remember it. These 18-year term plans, the main way people are talking about them is they're introducing them, that it wouldn't affect, the current members of the court would be grandfathered, because some of them would have to go if it were done
a lot of them, right. Yeah, and that's one of the things is like these reforms don't seem, it's hard to divorce them from the current ideological makeup of the court, but like having an enforceable code of conduct seems like we can all maybe get behind that, but, again, maybe not. The fact that Clarence Thomas was appointed in 91? Is that right? 91?
Yeah, 91, right.
So like, he's been on the court for 34 years now?
33 years. Yep.
Yeah. Long
goodness
time.
gracious. So
and that's when I started covering the courts.
Oh, that's right. Yeah, we talked about that first time. Right. Well, it's not time for you to retire.
No.
That's all I'm going to say.
Don't go anywhere, Mark.
I'm planning to stick around as long as I can. There's no term limit on people covering the court.
We appreciate it because we very much value having you on, and we look forward to having you back.
And we read everything that you write for Ed Week.
And it is also the source of many of our bell ringers. So thank you for that, too.
Yes, thank you.
Well, that's so nice. You guys just say that.
Yeah. And we're going to see you in a few months in person, right? At the Education Law Conference, Education Law Association's annual conference down in Orlando this year, right?
Yes. And I have some kind of similar things that I've either already done recently or doing. So I kind of try to workshop some of my material because, I try to make it entertaining, and usually the justices make that pretty easy for me.
Yeah, exactly.
Your keynote is always a highlight of that conference.
Oh, 100%.
So yeah, if you need to run some jokes by you, we've got a platform for you.
Yeah. So, and if you want to see Mark in person or us in person,
that's true. We'll be there too.
We'll all be there. It's early November in Orlando. Yeah, November 6th through 9th. We're going to record a couple of episodes live there. Mark's got his presentation that he gives that is awesome and fun and funny, and tons of other presentations, all focused on education law. It's a great conference.
It's a good group because it's a lot of professors, but it's also legal practitioners. But, I met high school principals there and all kinds of people who just have some sort of interest in this.
Yeah, it's everyone who is fascinated by school law and just likes to geek out and nerd out about talking about it.
Yeah, so if you're listening to this podcast, it's probably you. This is the audience.
I was going to say, yeah. That sounds like our audience.
Yeah. So, all right. Well, anything else that we should cover before we sign off for this week?
Not that I can think of. Just one more big thank you to Mark Walsh for joining us. It's absolutely a pleasure to have you on here, and we're so glad that you take the time out to talk about all the fun things going on with the court and education.
Well, thanks, Chris, and thanks, Jamie. It's always, I've done it twice now, and it's a lot of fun for me because I do have to think about some of these things. And sometimes I quickly forget a certain case that maybe passed through pretty quickly and got denied cert or something. And I go back and take a look at it. And it's just, I love talking about these things too. So always happy to do it.
Well, we'll have you on again. And in the meantime, we will look forward to seeing you in November.
All right, guys.